We will cover a couple of different housekeeping items as it starts the presentation, but I do just want to let everyone know that we are recording this presentation, and it's going to be available in the days to come on both the Catalyst Group website as well as the Prinz Law Firm website. So if there's anything you want to come back to, you'll absolutely have access to this. And then, this afternoon, you're all joining us because we're going to be covering a pretty important topic, and that's the topic of executive agreements. So many of you have been through the process of negotiating executive agreements either for yourself or on behalf of the organizations that you represent. And some of the people that are joining us this afternoon are actually going to be getting ready to negotiate executive agreements for themselves in the years to come. So I appreciate you logging in. So it's not until we find ourselves in the position of negotiating these executive agreements that we recognize that it's time to reach out for help. So we appreciate Amit getting involved with us today to make sure that he's giving us guidance on things we need to be aware of to really ensure that we get it right the first time that we're doing this. Because ultimately, as we're getting into these negotiations, it's because we're looking to either move into an internal role for years to come, or we're joining a new organization. And it's really important to get it right from the start so that you can spend years there and not months because something's been set up incorrectly. But also so that you can rest with peace of mind that no important items have been left unaddressed or open to future interpretation. So again, we're thrilled to have Amit with us this afternoon, and we appreciate the insight he's going to provide regarding negotiation advice and tips for executive agreements. Amit is an accomplished employment law attorney and a partner with Prinz Law Firm here in Chicago. He's also an adjunct law professor at Loyola University Chicago School of Law and a member of the associate board with Chicago Debates. So Amit has extensive experience working with executives and companies to find creative and pragmatic solutions to employment law problems. And perhaps it was fate that brought Amit and I together nearly 3 years ago. But as a former client of his, I can tell you without pause that he is very effective and extremely efficient at the work that he does. And it's really no surprise that he's been recognized as an Illinois Rising Star by the Super Lawyers magazine annually since 2016. So without further ado, Amit, the screen is now yours. Thank you very much.
Thank you, Kevin. I appreciate that. I think Kevin would also agree, though, he had wished he had spoken to me maybe 7 years ago as opposed to 3, because then things would have been a little bit easier. I also want to do some housekeeping as well. Feel free to ask questions either in the chat or by unmuting your mics. It's always better for these things to be interactive. I'll be cognizant that we kind of have folks on both sides of the aisle. I don't want anyone to walk away from this thinking, I wish I'd asked that question or I didn't understand that. I think we're all kind of in the same boat and we all are thinking the same thing. So feel free to, again, jump in, ask questions whenever, etc. And I think it'll be something the entire group is going to want to know about. So as Kevin said, I kind of do stuff in all aspects of employment law. I am going to focus this a little bit more so than maybe other folks on non-competes and non-solicits, but that's just because honestly, I do a lot of that. And so it's confirmation bias more than anything else. But again, if you have other questions too, feel free to jump in and, we'll do our best to kind of accommodate everyone. At the end too, if we have some time, I'd like to just go over some general negotiation theories and strategies as well, because I'm sure you all are thinking about that too. And I'll do my best to balance this both from like a management side and from an employee side, since we have people on literally both sides of the aisle in the same role to some degree. So I think the first thing that's important to kind of think about when you're looking for a right position in your search programs is to kind of determine the goals. Everyone here is going to be in a little bit of a different situation. I think we all are going to hopefully be in a spot where there's multiple offers. We can be a little bit pickier, and it's not just taking something as it comes across from us. And so because of that, the goals then matter. What is the goal from a financial standpoint, a lifestyle standpoint, a workplace culture standpoint? Even for me personally, the first adult job I really had was my current firm, and the culture really mattered to me because this is where I'm going to spend most of my day and my weekends. And given my profession, I get yelled at a lot. So I just need to be in a place where I like my colleagues and I get along with my team. And that was super important for me. Which I think then means it's super important then for you all to be doing due diligence. And so that means when you're being interviewed, you're also interviewing them. And I think that's something to be cognizant about too. I think researching employers can be a double-edged sword because a lot of times when you look for stuff online, it can be tricky. You can find stuff on Glassdoors, et cetera, that go both ways. It can be disgruntled employees that don't necessarily represent the employer properly. It can also be, for lack of a better phrase, planted employees too. So I think you want to be a little bit more cautious through that approach. I think one of the best places and best ways to, or two best ways to really figure this out are either A, look at the turnover. If you're applying for a place with a lot of employee turnover, that's probably not a great sign. And B, the support staff and how their tone is and how they feel about the workplace. There's pre-COVID, there was a bar that was near me I could occasionally go to, but not too often, because every time I walked in, I could tell the employees didn't want to be there. And so if they don't want to be there, do I really want to be there? And I think that in a weird way works true for support staff. If you're walking in and you're meeting with people and it generally just seems like a place where people aren't happy, then that likely starts at the top, and that's probably not a place you want to be considering. So I think this is one of the most important things too, because if things aren't going to, if it's not going to be the right tone for you, then there's probably going to be a higher likelihood of issues within the employment relationship. Now, we're going to talk a lot about key contract terms. And so that includes the term and termination language, the compensation, the benefits, restrictive covenants, and court versus arbitration and other clauses. I'll do an overview kind of from both sides too. And if any of this is too high level, let me know. As an attorney, I have to do my own disclosures, which means I'm technically not giving anyone any legal advice today. This is mostly general information. And a lot of this is publicly available. As Kevin said too, I do teach at a law school. I teach a legal writing class, and I do often teach both negotiation courses to other executives and also restrictive covenant courses to other attorneys too. So those are two things I do a lot of, and I personally draft a lot of agreements for corporations and also negotiate them from the employee side too. So I think that experience on both sides of the aisle gives me a different perspective than most folks. But one of the most important things for both sides is to document everything. When you first start off a relationship, things are going to sound great and they're going to seem awesome, and you're going to have this honeymoon period. But the whole point of the agreement is when you have the divorce, and then have you captured everything that matters to you all in writing. You can't rely on the oral promises. You can't rely on anything that's not within the document itself. And I also think it's super important early on to realize if someone doesn't want to put something in writing that they're agreeing to or saying they're agreeing to, that in of itself is a red flag. Like maybe they are going to maybe there is a reason to push back, but if they're saying, hey, we're going to pay you this way or do things a certain way, but they don't want to put that in writing, that's a problem, because that means to you that's maybe not a promise they're going to abide by, and there's going to be future issues as well. And if the agreement doesn't make sense to you, then it's just candidly a bad agreement. One of my favorite stories is a colleague of mine who told me about a client who called him up and told him, hey, look, I read this contract you drafted for me, but I can understand all of this. It seems too simple. Like, is a court going to enforce this? And the answer was yes. It's exactly what you want to do. Because the way you want to think about these contracts is, a judge is going to have to read this potentially at some point on a Tuesday afternoon when they have a huge stack of paperwork. If they can't understand this and you can't understand this, then it's just not a good agreement. And so anything that matters to you, and I mean to you specifically, and either side of the aisle, make sure that is clear language where there's no ambiguity, because that's really what's going to matter. And I really like using the test of a tired person on a Tuesday afternoon when they're in the middle of a busy workday with a huge stack of papers. If the language is unclear to that person, then you got to fix that language, especially for promises that matter to you. So the term and termination, most people are going to be at will, which means they can be separated for any reason at any time. Occasionally, you're going to be able to negotiate some provisions that means you're not at will. And so that's really what we're talking about, especially because I think hopefully some of the people in this audience are able to leverage a little bit more stuff for themselves. Sometimes agreements are going to have cause periods, which generally means that there's going to be, without cause notice period length provisions. And what you want to make sure there is that it's mutual. If the employer is asking for 2 weeks or the employee is asking for 2 weeks, you want to make sure that's the same for both sides so you're on the same page. Sometimes you can have cause language, and the reason for the cause language is going to be the employee's getting some sort of benefit if there's going to be separation without cause. But the employee's got to be careful, and so does the employer, that the cause language is finite and definitive, and so it doesn't allow too much ambiguity. And this can happen both ways. On the employee side, there's oftentimes going to be cause language that allows anything basically to be cause. So for example, if an employer says, hey, if we separate you without cause, or you have to terminate with cause, then we'll give you severance, or we'll reduce your non-compete, or we'll give you something. it's important that that clause language can't apply to every scenario under the umbrella, because then it's meaningless. And that means you're not really getting that benefit. So really play through the worst case scenarios of those definitions. And sometimes what we'll do is there'll be, if there's a material breach of this agreement, well, that can mean a lot of different things. So include in a written notice period of, if one side provides notice of a breach, the other side gets 30 days to fix it, something like that. Those can be pretty reasonable provisions that decrease the level of ambiguity or discretion within these things. So that way you're all on the same page and it doesn't apply to a whole host of scenarios. And I would read those clause provisions carefully on both sides, because that's where on the back end everyone gets upset, because they think they're promised something and then they realize, oh, this applies to so many scenarios that there's not much I can do. It's so watered down. So watch out for stuff like that. Garden leave or similar provisions typically arise in the context of non-competes. And this is going to be industry specific, as is the term language too. In some industries, there are more guaranteed terms. For example, with physicians, typically it's going to be like a 1 to 2 year term. And oftentimes both sides have to give the other side 3 months of notice. And there's a reason for that, because there's patient care issues at stake. And similar for garden leave, a lot of times in the financial industry, you'll see situations where the non-compete will have a paid leave period. And we'll talk more about non-competes and non-solicits. But these agreements can sometimes have something like that, where there's essentially like a transition period so that the company can go from one executive to another executive in a seamless process. So watch out for those provisions too, or negotiate those provisions. Those might be things that make sense for both sides, and there can be benefits. So by having some sort of transition period or notice leave period or garden leave period, the employee can get maybe some sort of guaranteed pay or severance, maybe a lower non-compete, and the employer gets a seamless transition between one person and the other. So these are kind of mutually beneficial provisions that can kind of help everyone, and some things you can be creative about. Now, compensation. This is obviously a very important provision, and I think it depends too upon the role and the industry. So base salary, I think a lot of times I'll work with folks who are in the startup world, and there is this sense of, we'll be willing to give up some guaranteed money versus more incentive compensation. And it's candidly, I'll say 9 times out of 10, folks don't get to that incentive comp. And so I think this goes back to the original goal conversation we had. What is the goal of the role you're taking? Do you want more financial stability? In which case, maybe you're giving up some upside. And so that's just one category to consider that. You can maybe push for higher guaranteed money, but that maybe means you won't get the potential boom scenario. And that may just depend too upon where you are in your career and life, etc. Is this going to be a job that you need for your retirement? Is this something where you want to gamble a little bit more, etc.? But I'll say this again, the startup industry, at least with people on both sides of the aisle, a lot of times when there's promised equity, sometimes it doesn't materialize. So be cautious of that and do some thorough research upon what is the actual likelihood of being able to get it. Because obviously when you're negotiating, that's going to be a huge selling point, but maybe you don't get there. Signing bonuses, I think, are things people don't try to negotiate enough of. And this is basically upfront money. This may cover some legal fees for review of your contract. It could be transition money. Maybe you have to do a buyout of a non-compete, etc. So this money can be used for those reasons. The key with signing bonuses, though, besides negotiating them, which again, I don't think people do enough of, are going to be the repayment terms. Because a lot of times these signing bonuses have strings attached to them. And those strings are in the context of, if you leave within a certain period of time, you're going to pay back the signing bonus. So there's a couple things to be aware of. One, what are the strings, if any? Two, can you renegotiate those? So for example, if it's a 2-year return of the signing bonus, can you do that as a pro rata share? So that way you don't have to do it. If you work for 23 out of the 24 months, it doesn't seem like you should have to give back the entire signing bonus. And 3, and this is going to be a common thing we talk about a lot today, it's just good to know the answer so you can have a plan, right? So if, for example, you are going to have to give back the signing bonus if you leave within a certain period of time, and it's going to be the entire signing bonus, it's really important to know that so maybe don't touch that money, just to be safe, just from a financial planning perspective. Another thing that can go under the bucket of signing bonuses are basically relocation bonuses too. I know there are other things to negotiate, especially if you are moving from one area to another area. Commissions and other bonuses are also super important to know, especially the timing of the payment and again, the strings attached. Depending on your industry and your role, you may be able to get commissions, or you may have incentive bonuses that materialize depending on how your personal performance is or the company performance. There's a couple key things to note though for these things. First is going to be the timing. And the timing matters both to determine when you're going to get paid, but also from an exit standpoint, because generally you're probably going to be leaving some money on the table. And so this dovetails well again with a signing bonus conversation too. If you're going to have to give up your Q3 bonus because the way it's paid out is you have to be employed on the last date that the payments would be coming in or whatnot, then when you're negotiating with a new employer, that's something to be cognizant of saying essentially, look, for me to come take this job, I have to give up my last bonus, which I expect to be Y amount of dollars. So can I get that in the form of a signing bonus through you? And knowing the timing can also impact your own financial decisions, what you're going to negotiate from a guaranteed compensation standpoint, et cetera. It's also important from a commission or incentive compensation standpoint, especially if these are dollars and cents you're banking on, to have more objective metric as much as you possibly can. Because you want to know how these things are calculated. You want to be able to review the paperwork, the documentation, et cetera, so there aren't any discrepancies. And these are red flag issues too. If early on into an employment, these are things that are already becoming problems, then that indicates to you that this may not work out long term. So definitely have a heightened sense of essentially spider sense more than anything else early into a relationship. On the other side, on the flip side, if you're an employer, on all these things, you want to be cautious too. Incentive compensation sometimes can be better for an employer, but it might mean you're going to have to pay more money potentially in the long run to an employee, which maybe is good, right? The better the employee performs, the better the company performs. So it's mutually beneficial for everyone involved. From a signing bonus standpoint, you don't want to fork over a huge amount of money at the forefront, but then have someone leave within 3 days. So maybe you do have some pro rata share of, hey, if you leave within 2 years, you've got to give us back some portion of that because we think that's fair. And same thing with commissions and other bonuses. What companies need to be cognizant about is not having a situation in which those are in perpetuity. You don't want to end a relationship and then still be on the hook for commission checks for 2, 3, 4 months after the fact or longer. So I think the verbiage of how these things are paid is super important. And because these things are wages, there are going to be additional protections for employees under the Wage Acts in the state's jurisdiction. So, for example, Illinois has the Illinois Wage Payment and Collection Act. So earned wages mean something different, and there are additional penalties for not paying those earned wages. So the verbiage and how these things are written in agreements is really important, and the weeds really matter on these things. And so even from a management side, when you're negotiating agreements for your teams, those are things to be cognizant about. Equity is one of those things that I think people take for granted in a couple of different ways. You know, people love to be on the receiving end of equity and to be getting equity, but I don't think people truly understand what their equity means. And so there's a couple important pieces to really understand from an equity standpoint. First is the vesting schedule. When does the equity even vest? Because again, when you're planning an exit from an employee standpoint, that's super important to be doctoring or to be calendaring, to know, hey, every January, I'm going to get a new tranche of equity. So if I'm going to leave, I should be leaving in February. Or if I'm going to be giving up some equity that's about to vest, maybe that's something I need to negotiate with my new employer from a guaranteed comp or signing bonus or something to be able to make up for that lost income. So the vesting schedule is super important. There's pause language in these equity documents too. And so that's another thing to be at least cognizant of or aware of, to understand how, in what circumstance am I going to be giving up my equity because of the separation, et cetera. And the final thing is equity agreements typically have separate covenants. So you're going to potentially have restrictive covenants in an employment contract or an executive contract, and those could be, non-competes and non-solicits, and then there could be separate equity covenants too. Like there are definitely scenarios I'm aware of where an executive may have a dozen different covenants between all these different agreements. And so sometimes you have to create a table just to know what your obligations and responsibilities are and what you can and cannot do after a separation. And equity agreements, depending on your jurisdiction, especially from a covenant standpoint, can have a bunch of weird nuances too. There's, in some states, and we'll talk about this a little bit later, those agreements can be worded differently and treated differently than a traditional non-compete. And that's important to know too. And the main reason is, again, from an exit standpoint, you need to know, ideally, you're hoping to stay at this employer for a very long period of time, but if things don't work out, you have to be prepared for that worst case scenario, so you're prepared from a financial planning standpoint and a plan B standpoint. So when you receive equity agreements, even if you can't negotiate them, it's still important to know what they say. And I think that's one thing where people don't invest the time sometimes, and especially those agreements, in my opinion, are usually written the worst because no one's reading them. And so when you do get them, even if you can't negotiate them, still I would recommend reading through it so you understand them as best as you can. And maybe you can negotiate them, try. I mean, there's no downside. Worst case scenario, you get a no, but at least you understand that that's the case. Some other compensation things are going to be severance. Higher the level you go, the more likely you are to be able to get severance. Severance can be in a couple different forms. It can be guaranteed through the context of your executive agreement. Companies may have severance programs already set up, and that could be based upon years of service to incentivize people to stay from a morale standpoint, etc. So not only should you be pushing for that in your agreements, but that's also something you should be asking for generally. Is there a severance plan in place that if I'm here a decade, do I get upon separation without cause a week for each year, etc.? Is that something that's within some plan documents? Those are important questions to know because that can also help you prepare when you're considering multiple different offers. And the final piece is going to be change control language. This again depends on the higher level you are or the type of company you are. And generally too, I'll use this phrase a couple other times too. A lot of these are just like tools in a toolbox that you want to keep. So you want to have a bunch of different options, and depending on where you're going and how much flexibility you have, you may ask for different things. So maybe if you're going to a startup, you want to push for change of control language or severance language. You might be giving up some guaranteed money, but then you can have some more back-end requirements that allow you to be financially secure. If you're going to a place that is a bigger shop where you can't negotiate some of those things, maybe you push for a bigger signing bonus where they do have some more flexibility. And maybe those are places where they would have some severance or equity options that you wouldn't otherwise be able to get. So again, it's just going to depend upon your goals, where you're going, but just keep all these things in mind because you want to be nimble and flexible depending on what you're negotiating and where you're negotiating. Benefits. Some of these things you can negotiate, some of these you can't, but it's still important to know what the benefits are. And again, it's having more tools in your toolbox. So there's the traditional benefits of health, dental, and vision, and kind of knowing what you're going to be receiving, disability, life. Retirement can be 401k matching. That's another one though where it's important to know, what is going to be the vesting language. When do you get to keep your 401k type stuff, those types of things. Some of those things, again, you can't negotiate because they're plan documents, but still important to know. So that way you can plan your exit. The biggest thing is being able to have some foresight into what you're going to be doing moving forward. Vacation. Now, vacation, I think, can be tricky because sometimes you'll get situations where an employer will say, we provide unlimited vacation or we provide you with 30 days or 45 days of vacation. But that can be meaningless because if no one in your company is using those vacation days, then that's not useful vacation to you. So, factor that in too as you're investigating or negotiating. Are people using vacation? What is a vacation policy? How does that type of stuff generally work? How is a payout at the end of an employment? Also, if you're given a lot of vacation, is that going to be able to cut against your ability to generate incentive compensation or commissions? That type of stuff. So be kind of thoughtful and creative in terms of what all these things are generally going to mean. I know right now I don't think anyone really is driving too much, but car allowances, depending on your job, can be another thing to potentially push for. And then networking fees, association membership fees, those can get pretty pricey sometimes. So those are other assets potentially to have in your toolbox. And if we have time, we'll talk about different negotiation strategies, but sometimes it's useful to have some things you're willing to concede upon, on both sides of the aisle, that aren't important to you, but you ask for, because that way when you're negotiating, you say, well, I can give up this and say I'm giving something up because it wasn't that important. So a lot of times too, what I recommend to people when we're negotiating something on the forefront is to have a list of priorities. So that way you have your checklist of stuff you care about, stuff you don't care about, because that makes it a little bit easier to negotiate these things too. It also kind of gives you some perspective on what you personally care about, which I think is really important because sometimes people don't know what they're going to value and they haven't thought about these things a little bit further down the road. All right, so we're going to move into the restrictive covenant conversation. Before we do that, if anyone has questions, feel free to use the chat options. Feel free to just ask questions through as well during the conversation too. So there are several types of covenants. There's confidentiality agreements, which can limit the ability to market to customers. Essentially, what a confidentiality agreement says is you will not use the company's information for any other purposes outside of your employment. These things are very broad. They cover a whole host of stuff, and they're really in vogue right now for a lot of reasons. One reason is just everyone is doing stuff on multiple different devices. And so because of COVID, I think there's this huge transition and companies are trying to get up to speed. And there's just a fear that information is going to get lost or stolen or co-opted. And so in my experience, this is something that's pretty big right now. I also think this is big right now because companies are maybe hesitant to try to seek a non-compete lawsuit in the middle of a pandemic. So a roundabout way of doing that is to try to enforce confidentiality obligations. My recommendation to people is be very, very careful about these things because it's quite frankly very easy to violate a confidentiality agreement. Pretty much, if you are traveling and you send yourself an email with some company information because you need to print it, that's likely going to violate the confidentiality agreement. And so be very careful about stuff like that. And, there's capital C confidentiality and little c confidentiality. Capital C is definitely going to be stuff companies definitely care about, like pricing lists, stuff like that. And so even if you're trying to do something innocuous during your employment, a lot of companies, when you're leaving, are going to go through your emails. They're going to go through what you sent yourself, what you printed, et cetera, because they want to see, or if you're going to a competitor, if you're staying within the industry, what are you using? What are you doing? And so you want to be very careful about that you're not violating those things. And then so two, and we'll talk about this later as well, one thing to do is a lot of these agreements are going to have clauses that say you have returned all company information at the end of your employment. Frankly, that's impossible to really affirm because you don't know to some degree. You probably have sent yourself an email or printed something. So try to include language that says best efforts, good faith, stuff like that, you're trying your best so that way you don't end up in a bad situation. I've heard of stories where someone has entered into a severance agreement where they made that promise. The severance was paid over a period of time. Company got into litigation. And during that litigation period, the employee found a box of papers that are relevant to the lawsuit. So they have to turn them over. So now the company's upset for obvious reasons, but then also that's a violation potentially of their severance agreement, so they stop paying the severance. So be careful of stuff like that and try to avoid it. From a company standpoint, I do think it's super important to try to protect your capital C information. And it's going to be true for trade secrets. It's true for non-competes. Sometimes it is use it or protect it or lose it. If you're not protecting your information, is it really confidential? And so you want to be very, very cognizant about that and be, again, keep your spidey senses up to make sure that information is being protected and not just thrown out into the marketplace, because otherwise it's going to be later to enforce those things later on. A lot of times we'll advise companies to say, on someone's last day of employment, make sure you're reminding them of their obligations, both confidentiality, non-competes, non-solicits, making sure they're returning property, et cetera, because that's kind of the best time to do it and to really, highlight that to employees. And I know a lot of companies do that. Some executive agreements will even include basically a draft form to execute on the last day of employment that says basically, I recognize I have obligations that continue. Those include confidentiality. I've returned all company information, laptops, emails, property, tangible, intangible, et cetera. And I think that's a good practice to get into. Now, there are Trade Secrets Act both at the state and the federal level. At the federal level, there's a Defense of Fair Trade Secrets Act. Oftentimes you'll see certain language like that in your agreements on both sides when you're drafting them or when you're signing them. And the main reason is that when you remind employees of those obligations, it allows for employers to get additional remedies. And at the state level, Illinois has its own Trade Secrets Act. A lot of states do. The definition of a trade secret is a higher bar, but then the penalties are also much more severe too. So it can allow companies to get attorney's fees, punitive damages, et cetera, but then you have to truly show something is a trade secret. And it also does require that you're actually protecting information. A lot of times the executive agreements will have inventions language. It takes various forms, but the short description of it is basically that a company can possess an individual's inventions after they leave. So if someone develops something through the course of their employment, that's theirs. And so there will be disputes about that in certain industries over what is an invention. Like in the context of Barbie dolls, I think there's been some litigation over if someone, creates something on their free time, is that Martel's invention or not? And so you'll see that sort of litigation as well. And so be careful about that on both sides of the aisle. So non-compete agreements are ever changing. I do a lot of this work, and candidly, we've been working on pretty significant reform legislation in Illinois that I'm hopeful will become public soon and will hopefully be passing because it might be bipartisan. Generally, a non-compete agreement is going to prevent someone from working within a chosen industry in a competitive setting within certain periods of time, uh, insofar as it's reasonable both in terms of time and geography and activity restraints. These things generally are not treated like a typical contract. There is a slightly higher bar. Courts are more likely to scrutinize these things because it's a restraint on trade. It's literally telling someone, hey, you can't go to work. And to some degree, it's bipartisan because an employer wants to be able to protect their information, but also an employer wants to be able to hire people. And so because of that, there is this weird tension where, folks on both sides of the aisle are kind of trying to have, enforceable agreements, but they also want to be able to hire people in the future. Generally, restrictions up to 2 years have been held enforceable. I've even seen some legal authority that's broader than that. It depends on the industry too. Reasonableness of the geography is going to depend upon where you work and what industry you work. So for example, if you're in the finance world, you may be bound by a restriction that's global. It could be anywhere in the world. Where for physicians or doctors, it might just be 30 miles of a practice area. And so again, the nuances matter. It's not a cookie cutter approach, both in terms of the restrictions and also in terms of the length of time and in terms of a bunch of different stuff. So even state law, and we'll talk about this a little bit later too, where there is no federal law on non-competes. So each state treats these differently. And so the state of the agreement, the state where you work, all of that stuff is going to matter. And that's where some of these things can get really confusing because there can be conflicting situations for the same individual. Non-solicitation agreements generally prohibit an individual from prohibiting the same customers or client accounts for a competitor. And there can also be non-solicitation of employees, which prevents an individual from soliciting former coworkers. Where non-solicitation agreements can be tricky is where they essentially become non-competes in disguise. So it is important to read these two things pretty closely. It doesn't matter what the header says. Sometimes a non-solicitation really is a non-compete. And I think a lot of times people don't understand the nuances of these agreements. So I think this is one place where I think people gloss over what these things say and generally don't have a firm understanding of them until they're trying to leave one employer and go to a new employer, and now they may be out of the marketplace. So like I said a moment ago, there's two aspects of the law that really matter. The law the agreement says applies and the law of your state, because there is no federal law on non-compete agreements. So, for example, in Illinois, there might be a situation where if an employee works for an employer for less than 2 years, that non-compete may not be enforceable. But in other states, that rule may not apply. So if you have an agreement, for example, in that says Florida law applies, but you work in Illinois and you worked for an employer for 1 year, you might be able to get out of that non-compete agreement. There's actually a case like with a similar fact pattern from 2008 where the court applied Illinois law because they thought that the Florida provision would violate the state's public policy. So that's why your state of employment matters too. And this is also why I think from a corporate standpoint, enforceable agreements are better when they're more, instead of being cookie cutter across the board, they're more situated to employees in states in terms of competitive activity, especially if the goal is to prevent if the goal is to prevent some sort of legitimate business interest or to protect some sort of legitimate business interest and actually prevent competition. It's going to be better to be more specific and narrow as opposed to broad. But again, some companies don't have that approach. They'd rather just have a simple situation, deter behavior, and try never to enforce one of these things. And another thing that really matters here too, in terms of your state of employment, is also your equity agreements. There are definitely going to be situations where you may have an employment contract that has a non-compete for a year that says Illinois law applies. You may work out of Indiana. You may have an equity agreement that says Delaware law applies, and that non-compete in the equity agreement may be 2 years. And so all of these things are important to know in terms of what the obligations are, where you're working from, what your state says about these things, and what law applies in each of these agreements. And sometimes, candidly, attorneys do have to make a chart just to figure out what's going on. But enforceability sometimes in these agreements can also be largely irrelevant, because even if the agreement is not enforceable, you still need a judge to say that. And so that can be a huge headache in a couple of different ways. An employer may not want to hire someone who's bound by a non-compete until they have some assurances, because they can be roped into litigation. And B, even if they're not roped into litigation, the employee may be roped into litigation. And so, as much as Kevin, I think, enjoys working with me, or my clients enjoy working with me, they don't really want to talk to me at the start of a new job. I'm the last person they want to be talking to. And this is an important piece to remember, too, in the context of a non-compete dispute. Typically, what's going to happen is you may get a letter on a Tuesday from a former employer's attorney saying, hey, you have to cease and desist and stop working. And so they may just send it to you. They may send it to your current employer, too. By Thursday morning, they may file a lawsuit trying to get you to stop working. And by Friday, we may have a court hearing. So that's already 4 days from the start to the point where I have to be in court. And so that means you have to get your ducks in a row. I have to get ready and prepared, etc. That's a lot of cost right there. Even if you win on that Friday at that hearing, the judge lets you continue to work, most likely there's going to be a trial set within 3 months, which means from the date of that hearing to the trial date, there is going to be documents to review, discovery to provide, depositions to take, etc. There's a lot of costs financially, because litigation can typically take somewhere between 2 and 7 years. And now we're condensing this period to a very small amount of time. So instead of spreading out that money, it's all within this truncated period. So there's a financial cost. There's an emotional cost of you're starting a new gig, all the stress that's weighing on you, etc. It's really hard to onboard. It's really hard to hit the ground running with a new employer when all of that is going on. And so even if you win, you may still lose, because what are you winning ultimately? You're still paying an attorney a lot of money. It's still a huge distraction. You're still starting off an employment on the wrong setting, and you're probably not getting accomplished what you want to be getting accomplished, which is why new employers oftentimes, even if they think a non-compete is not going to be enforceable, or do they really want to take that chance with a distracted employee who they want to invest in financially, who's now distracted? So again, it doesn't matter sometimes if it is enforceable. That's why it's really important just to avoid the situation as much as you can and have a good plan set up to do so. And if you do lose, the cost can be astronomical, because there's not only the cost of not being able to work, the attorney fees, you have to pay your own attorney. You may oftentimes have to pay the other side's fees too. And that can be very high. And they're probably going to have deeper pockets, etc. And again, like I said before, you may have multiple covenants. So it's really important to try to avoid this stuff as much as possible. Which means before you sign any agreement that has covenants, think of your potential next move. Have a plan B in place. What are you going to do if you had to abide by these obligations? Where are you going to go, etc.? And again, this is an evolving question, because it doesn't just matter at the start of your employment. It also matters when you get equity documents. You may get a new non-compete in the middle, or a non-solicit. So you have to game plan all this out, because you never know. Things always start off well. There's always going to be the honeymoon period, but the whole point of this is to have thought through the worst case scenario, so you never get to the worst case scenario. So at the start of your employment is also the best time to negotiate, because now you're not bound by anything. There's no obligation. It's a mutual setting. So that's when you can try to narrow the restrictions. This can be both in terms of time, geography. Maybe you literally name entities you don't go to, so you know what you can and cannot do. It's better, frankly, from both sides to know what can the employee do after they leave versus what they can't do. If you're bringing along clients or accounts, memorialize that in writing so there aren't any disputes later on. The last thing you want is 10 years after you've left a company for them to be suing you over a non-solicited client that you brought with you. But that's not anywhere. And then now you have to re-engineer and reverse engineer all this stuff to prove, no, I really brought company A, B, and C with me. Those are my clients. It's better to have that stuff in writing at the forefront. Try to negotiate some form of carve-out language that is going to be dependent upon determination. So for example, if it's part of a furlough, or maybe a pandemic, or it's without cause, maybe then non-compete is not enforceable. Those are all things you can try to do at the forefront. Try to negotiate a severance that's tied to the non-compete. And severance maybe is not even the best term here. It could be paid leave, etc. So that way, you're at least generating some income during the sit-out period. But this is an important aspect to add here. The sit-out, if you're going to get paid leave during the sit-out period, make sure that amount of money is consistent with your compensation. Because a lot of times what will happen is people will have situations where their base salary is just a small fraction of what they're actually making, because most of their money is tied to incentive comp, as bonuses, et cetera. And those bonuses can be very large. They might be 3, 4, 5x of their base salary. So a lot of times you may get a 6-figure salary and you sit out for that for a year and you get a 6-figure salary, but that is a huge pay cut to some people. So think about that critically too, of like, where can you negotiate certain things? Maybe then instead of getting the paid salary, you have, a factor of your total comp from the last year. Or maybe then you play around with the length of time, etc. Try to make the attorney's fees provision mutual. Now, again, it depends on the state. In Utah, if an employee wins a non-compete lawsuit, they get their attorney's fees. And that's what we're pushing for in Illinois, too. We're pushing for a lot of things, and that's one thing that may come across soon. But regardless, try to make that provision mutual. Or at the very least, make it silent. It's bad when it's one-sided. That obviously it's not in employee's interest, and it being mutual is better. I think one important thing about all of this, to kind of dovetail off of something I said earlier, is if an employer isn't negotiating on these things, that's a red flag. And that's something you've got to be cognizant about too, because it means then they're going to try to do something on the back end, and you got to be prepared for that contingency. We talked about this earlier, but qualifying language for return of company policy. Essentially, like, I've done best efforts. I've searched through everything. If I find anything in the future, I'll immediately delete it. Anything like that is inadvertent. Those types of things. But just be very cautious generally from the very beginning of an employment, especially right now where technology's at our fingertips, you have personal devices, etc., of emailing work stuff to your personal devices, to your personal accounts. Just try to avoid it as much as possible, because inevitably what's going to happen is, especially when things go south, the former employer is going to look through your emails. They're going to find these things. And what was innocuous on a travel trip in 2021 is not going to seem innocuous in 2030. So just avoid the headache as much as you can. And you can try to include waivers too, like, consent to working for another employer will not be unreasonably withheld, etc. And I think from an employer standpoint, again, I do think if you care about your legitimate business interests and you really want to stop certain type of competition, it's important to be specific, to evolve your agreements, and just understand the area of law. But again, it just depends on the goal. Some employers prefer just to have one size fits all approach because they just want to deter it and they don't actually want to file these lawsuits, and that's fine. But I'll tell you this, the clients I know who come to me after they had one of those types of agreements who want to enforce things, they're not happy. Because at some point you may want to enforce those things, and it's just much harder to do so when you haven't put all your ducks in a row. It's the same thing. Both sides need to be planning these things out and game planning to make sure they set themselves up for success. Because the last thing you want to do is not be in a good spot on the back end, and now you're just kind of in a tough spot of like a key person has taken a bunch of information, and you can file a lawsuit, but it may not be successful. Upon your exit, there's some other things you can do too. One is maybe you have, let's say in a scenario in which you didn't negotiate any of these things, and now you want to try to get out of your non-compete. Well, maybe you have some legal claims. You can use those legal claims as leverage to get out of a non-compete agreement or a non-solicit. So be creative. Sometimes you have to give up an apple to get an orange. So it's okay to do that. And with a new employer, you can try to negotiate indemnification language. One of my favorite cases, actually, I'm jealous actually of the way this played out. Because I didn't work on it and I wish I had. There's a case where an employee was a salesperson for a company, and Illinois generally was requiring 2 years of employment or some other benefit for an enforceable non-compete. And this employee had not received any benefits of the non-compete. The employee, and at that point, actually, sorry to go back, the employee had no non-compete. So the sales agent works at a car dealership, Harley dealership, I believe, or motorcycle dealership, leaves, goes to a competitor, works there for about 3 weeks or so. I don't remember the exact timing, but a short period of time, doesn't like it, comes back to the former employer. Well, now they want the individual to sign a non-compete, but no additional benefit besides the actual employment. Employee then works for 18 months, sets it up so his new employer is going to indemnify him from any non-compete lawsuit, so pay for all of his attorney's fees, as long as he doesn't take any confidential information or use anything. I think it was about 18 months of the employment, definitely less than 2 years. He leaves. Make sure he gets his commission check. I think he left literally a day or two after he got that commission check. Goes to the new employer. Old employer sues him. His fees are covered. He wins the lawsuit. No injunction. And so that's a perfect example of game planning this out from the employee standpoint of making sure he got the commission check, making sure he got covered on his attorney's fees and having a new job lined up, and he was good to go. Now he still had to, the new employer wanted to invest in him. He was still distracted by a lawsuit, but it worked out for him, and that was great. So that's the same thing. You can try to negotiate these things if you think it's going to be an issue. And sometimes at the forefront of a new relationship, you can do a buyout. They might be able to pay, money towards the old non-compete, so there isn't a dispute. Maybe they just write a check and then you're good to go, free and clear. So those are options. And sometimes you can get the employers to negotiate directly, which is good for you because you're not spending any money. And it's the same thing from a company standpoint. These are other options too. If there's a talented employee you really want to recruit and you don't think the non-compete's enforceable, maybe you do that. I don't think that new employer in that hypo I talked about was really that upset because they got a very good salesperson who was probably able to generate a lot of business for them. And that business was more so than the cost of litigation. So these are all things to be planning out too from both sides of the aisle in terms of how you want to leverage these situations. My biggest advice with these things though is either definitely try to negotiate these things, but definitely be aware because there's not much, sometimes there's just not much you can do on the back end, and it's better to have the foresight so you have a plan in place in terms of what you're going to do. There is a bigger trend right now in terms of arbitration versus court. So I want to break this down a little bit just so people on both sides kind of understand what the differences are. Court proceedings are generally going to be less expensive because you only have to hire an attorney. You don't have to pay. You have to pay a filing fee to go to court. You have to pay for like certain costs, but you're not paying the judge. For example, your taxes do that already. So you're not paying an additional sum to do that. It is more public. You can get certain types of things under seal, but generally court proceedings are open to the public. There's public records, especially in your federal court. Anyone can look up a case. It is typically a slower process, especially right now because there's a pandemic, so there's a backlog. Typically lawsuits can take anywhere from 2 to 7 years in a court proceeding. Jury trials are going to be pushed off for a while now because it's hard to get people in a room. And in court, there is an opportunity for both sides to appeal. A trial court decision can be appealed as a matter of right. Going to a state Supreme Court or federal Supreme Court or the U.S. Supreme Court can be harder. But that's still one level of appeal you're almost guaranteed. You are guaranteed. In the context of a non-compete dispute, for example, these things can take start to finish from the start of a lawsuit through the end of an appeal, about a year, sometimes a little bit longer, 15 months. Whereas a non-compete lawsuit can take somewhere between 2 to 7 years. And the reason I give that hypo is so you have an understanding of the costs associated with that. Basically, you're taking costs that could take 7 years and you're condensing it down to 1 year. Arbitration can be more expensive, but this is changing because, especially in the employment setting, more and more and I'll back up for a second, more and more arbitration associations have their own rules. So there's different associations. There's, for example, AAA, the American Arbitration Association, or JAMS, and they come up with their own rules or procedure for arbitration settings. And they may have their own arbitration rules for employment settings. And so because of that, more of these rules are requiring the employer to pay the attorney's fee, or to pay the arbitration fees, sorry, not the attorney's fees. And so because of that, it can be more expensive for the employee sometimes if those rules don't apply. It can also definitely then be more expensive for the employer. And so a lot of times I think from an employer setting, it may not make sense to have an arbitration clause. It is private though, and that is a benefit because it's not going to be as open to the public. It's harder to find decisions. It's a faster process, but this cuts both ways. Sometimes it's harder to do motions in arbitration, but it's easier to get away with doing less discovery. So there's cost benefits to both sides on that aspect of arbitration. I know right now some attorneys on both sides kind of prefer arbitration because of the COVID aspect. But there's almost minimal to no opportunity to appeal. Arbitration awards generally are upheld. There's very few circumstances in which those can be appealed. And so I think from an employee situation, you kind of want to be cognizant of all of these factors from a cost standpoint. Also, arbitrators typically are former judges or attorneys. They may have relationships with the management side. And so that's why sometimes management side or employers want to have arbitration. But it can be more expensive. And you may not be able to file the same set of motions you want to be able to file in court. You may not be able to appeal. But you also don't have to deal with a jury. And I think from a non-compete standpoint, it can be a little bit dicier too. So I don't know if there's a firm answer for either side. Another thing I should touch base upon too is there is a bigger emphasis right now on class action waivers, both in the context generally, but also in the context of class action waivers that require arbitration. But that can also backfire. Uber is a good example of this, where Uber had a bunch of people sign class action arbitration waivers. So if people wanted to sue Uber, they'd have to do so individually. So what ended up happening is people filed, I think, over 100 individual lawsuits against Uber. So then Uber has to do 100 separate lawsuits. They have to pay for the arbitration costs, etc. And so I think they may prefer that to be in one setting. So these are just things to be thoughtful of. Again, I don't know sometimes if there is a right or right answer you can think of at the beginning, but I think the fact that you're having the conversation, you're thinking it through, is probably the most important aspect in a lot of these things, especially because these are going to be, to some degree, standardized decisions for a period of time that you're going to be making.
So Amit, a quick question for you. When employers are putting together these agreements, is it typical that you'd see in there an arbitration clause in terms of saying we all agree that we'd go to arbitration as opposed to court, or is that something that would actually be enforceable or not?
So yes and no. The answer to your first question is more of a yes. So there has been a huge uptick recently, I think, in arbitration clauses. And I think that's because there's generally been a legal trend towards enforcing them. And also because I think employers prefer the arbitration individual private setting. I think that's just a preference of theirs. And a lot of times, again, arbitrators can be more management side individuals. So I've seen more of these clauses in agreements. There's already state level legislation pushing back against that, and probably some federal legislation as well. And I've definitely seen at a minimum more class action waivers, basically saying employees cannot file lawsuits as a class, they have to do stuff individually. And that, I think, definitely in the context of arbitration can work, but also I think even outside of the arbitration context, I've seen more of an uptick of. In terms of enforceability, it depends on what the clause says. And so again, the verbiage is going to really matter. Generally, arbitration clauses are favored because of the Federal Arbitration Act, or the federal law on this, and states have their own individual arbitration acts. Where it matters, though, is if the arbitration clause is clawing out or getting rid of certain remedies available to employees. And so that can be, for example, if you have, let's say, the Illinois Wage Payment and Collection Act mandates that an employee can recover their attorney's fees in a wage dispute. Arbitration rules and arbitration clauses sometimes will allow the arbitrator a lot of discretion in terms of what remedies to provide, so they could ignore that. And because arbitration awards are hard to appeal or vacate, there's not much an individual could do. So one of two things happens in those circumstances. Either a court may just say, look, we're not going to enforce your arbitration because that's not an effective indication of the employee's rights, or they may just rewrite the arbitration rules so that that's not an issue. And that actually, to circle back to non-competes too, and generally employment contracts, courts can rewrite agreements or blue pencil them sometimes depending upon the state. It again depends on the state. For example, Illinois has a blue pencil rule which allows courts to make reasonable reformations to agreements, whereas some states like Wisconsin, for example, have a red pencil rule where they just strike provisions. So it does depend on the jurisdiction. But the short answer to your question is I've noticed an uptick in arbitration clauses. I've definitely noticed an increase in class action waivers. And whether or not they're going to be enforceable is going to depend on the verbiage, but sometimes courts will modify these agreements to make them enforceable.
And beyond just seeing this inside of an executive agreement, are you seeing these also coming up in employee handbooks?
I am. So handbooks are tricky though, because whether or not they're a contract can be some gray area. But for example, there was a U.S. Supreme Court case that came out recently, Epic Systems, where I think the arbitration policy might have just been emailed out. So, and sometimes these aren't in executive agreements. Sometimes these are standalone provisions that are there might be, for example, an offer letter an employee receives, and there might be a separate restrictive covenant agreement, and then there might be a separate arbitration agreement. So sometimes it's multiple documents that folks are signing, or it could be within an equity agreement. You may have a situation where you receive an offer letter, you have an employment agreement, and the employment agreement just says typical wages, court applies, and it's Illinois law. And then you may have an equity agreement that has a non-competes in it that says Delaware law, that has an arbitration clause or something to that effect, etc. So sometimes there might be situations where an employee is bound by multiple restrictions and multiple jurisdictions and multiple forms. So again, I think it's just important to know and be cognizant about that. But I've kind of seen this stuff across the board.
Got it. Okay.
So we are going to run up to 5. I'm going to try to do a very quick negotiation theory conversation. But if people do have other questions about this stuff, feel free to jump in. Because again, everyone's going to have similar sets of questions. But what I'll do quickly is I just want to do a very quick conversation about negotiation theories. This chart just shows kind of the north-south ends of things, the positional bargaining versus interest-based bargaining, and east-west adversarial competitive negotiation versus collaboration. And I think throughout the negotiation process, and generally, you just want to be nimble. No negotiator is going to stay in one area of the negotiations. It's important to be flexible. This is both when you're negotiating your own employment, but also when you're negotiating stuff for direct reports, for external playmakers, etc. I think it's important to know your own style. I think it's important to know your goals and what matters. But I think authenticity is also important. Just a very quick overview of competitive negotiations, really just focusing on yourself and attacking the problem. Versus collaboration is kind of figuring out a way to have a win-win situation. And I think where this gets tricky early on is when you're starting a relationship with someone, you just want to be careful because you're trying to navigate different things. Whereas you are competitive, but you're also going to collaborate. For example, in a sports setting, you may have a situation where Team A is playing Team B, and that's competitive. But at the same time, the players for Team A and Team B may have sometimes want to band together to negotiate a collective bargaining agreement. So this is generally going to be trying to cut the pie or making gradual concessions. This is why it's important to have a priority list of terms that you care about. So that way you know what you're giving up, you know what you care about, you know where your lines are in the sand. From an interest-based negotiation standpoint, that's where you're trying to expand the pie. You're trying to create a bigger win-win. So this could be a form of, incentive compensation. Like the more money the company makes, the more money the individual makes, so that's better for everyone. And so your interests now are aligned. And so that's a conversation, an entity might want to make of saying, look, we'll give you more of a higher percentage of company revenue or et cetera, but lower base salary to incentivize folks to expand the pie, essentially, for lack of a better phrase. But just generally try, it's best to have an understanding of what you care about, but also what the other side cares about. You can use collaboration to communicate to gain an advantage. You can accommodate sometimes. You can give up something you don't care about because it doesn't matter to you. And that also dovetails well with compromising. Sometimes you can use silence as a friend. I use it a lot. A lot of attorneys do in the context of a deposition because sometimes people just want to word vomit. But sometimes you have to be competing and you have to be unwavering, especially when you do know your lines in the sand and you know what you actually care about and what your priorities are. So the biggest negotiation tip I can really provide, and I think it is a theme of this conversation overall, is have a plan, research it, and use good communication skills. If you don't have a plan in terms of what you care about now and what you may care about in 5 years or 10 years or thought about that, it's just really hard to do these things. And then you're going to find yourself in a potentially a big headache, either because your compensation isn't where you want it to be, or now you may be out of the marketplace for some period of time, or potentially stuck in litigation. And candidly, I don't think you want to be talking to me on the back end of a job. You'd rather be talking to me at the beginning of a job. So with that, if there are any questions, feel free. Definitely read your agreements, call our office. And I really appreciate everyone's time today, especially Thursday afternoon when the weather is pretty nice.
Ahmed, it looks like we've got a couple of people that wanted to try to chime in. Darren, were you trying to get active with your microphone? Looks like we're trying to unmute you right now. 1 second.
Hang on.
There you go. Now you're live.
Hi, Emmett. I just wanted to thank you for your time. That was very interesting, very comprehensive. Perhaps more of an observation. I'm not sure if there's anything that can be done with it, but I see so many of these lawsuits on both sides. Either we're hiring salespeople, they get sued by our competitors. There's no real material damage, and that there's no materiality to it. I swear half of it is vindictiveness, out of spite that they're just sour that somebody had left them for a competitor, and they're just trying to cause financial harm to that individual. So it's a sad area, frankly, of business, and I think you highlighted some of the things we can do to try to prevent that. But it seems to me that the employers have definitely the upper hand because they can use lawsuits to their advantage in this, and then the employees at time of hiring really overlook negotiating out these terms. So I hope you were able to broaden your audience and engage
No,
people.
I'm 100% with you. And so that's why one provision, and hopefully this will pass in Illinois, but one provision we're trying to steal from Utah is that if an employer files a lawsuit against an employee in a non-compete setting, the employee can get their attorney's fees, because that will deter exactly what you're describing. Because I think you're right. I think a lot of times it's just business, right? It's a business decision where company A is upset that an employee went to company B, but they're trying to prevent that and deter that type of behavior, which isn't good for it's not good for the market. It's not good for employees. And so you're right. I don't know what you do outside of stuff like that besides just like clarifying, codifying. Yeah, and you're right. A lot of times employees aren't reading these things. And to some degree, I get it. Like who wants to read a 30-page equity agreement and the weeds on that?
Exactly. Yeah. But very helpful. Thank you for the time and presentation.
Yeah, so I can say I personally lived through a tremendous challenge. And 9 years ago, when I moved back to Chicago, I absolutely should have been in touch with Amit to make sure that we were collectively reviewing agreements that I was being requested to sign. And so if anyone ever has any questions, I'm very happy to make contact with you, and absolutely will, without any doubt or reservation, make sure you're in touch with Amit as well. He's really effective at what he does. I also had an opportunity to see him perform in front of the judge and competing counsel, and his involvement in a group called Chicago Debates is clearly something that he adds value to and brings to the work that he does every day. So I don't know how common it is that you get to sit with your clients in front of the judge, but I was grateful to have the opportunity to actually be witness to that and actually see you at work. So it's really neat. Speaking of Chicago Debates, it is an organization that Ahmed is involved with as an associate board member. And as we were talking about, we like to make donations in support of causes that people get involved with presenting to the Catalyst community for. So we're going to be making a donation in Amit's name to Chicago Debates to help them forward that cause. And Amit, if you wouldn't mind maybe just giving us a couple of seconds on Chicago Debates.
Well, thanks, Kevin. I really appreciate the kind words. And one thing I'll say too is I think talking to me early is a huge investment, both preventing a headache and even financially sometimes. No, Chicago Debates is an amazing organization. It sets up debate programs for Chicago high school and middle school students. Kids that debate are more likely to graduate high school, go to college, graduate college, and just be more successful. Most of the participants in debate programs in Chicago Debates are, in underprivileged areas. Many of the families are, household incomes are under $30,000 or living under the poverty line. So it's an incredible resource. I benefited from debate in high school. I grew up in the city of Milwaukee. I was able to go to schools in the suburb. My high school had a debate program. I learned a lot. It was an incredible, incredible experience. So I'm really grateful that Catalyst is going to be donating to us. What we're going to do is we're hosting a trivia night soon, and Catalyst is a sponsor for that trivia night. And I really, really appreciate that. It's a really awesome gesture by Kevin and his team, something they didn't have to do, and it's really awesome. It really is beneficial to the kids in the city.
Happy to be a part of it. So excellent. Well, unless there are any other questions, I want to thank Amit again for sharing his knowledge with us and for putting together a slide deck to cover many different points. There's so much more for us to talk about, but we also want to be respectful of everyone's time. And like I said, if you do have any questions, feel free to reach out to Amit directly or through me. Definitely send him a note to connect via LinkedIn as well. And we will get a recording of this webinar up on both Prins Law Firm's website as well as Catalyst Group's website in the next, I'd say, 5 business days. But thank you all again for participating. We really appreciate it. And thanks again for being a part of the Catalyst community.
Yep, thanks for joining. I'll stick around for a moment or two if people do want to just ask any questions. Otherwise, feel free to reach out to me offline. Thanks again.